we'll call is Alfonso Kennard.
Madam Chair, I have a question for you.
Yes.
There was a motion to dismiss filed. Do you want to take that up separately, or do you want us to just go into the arguments?
We'll consider it along with the merits.
Okay.
Thank you.
Good morning.
Good morning. Thank you both for your patience. I know it's been a long morning. We appreciate you being here. We'll call case number 65861 in the matter of Alfonso Kennard Jr., which is a reciprocal discipline matter. Please state your appearances for the record.
I'm Amanda Cates here on behalf of the Office of the Chief Disciplinary Counsel.
I am Ellen Sprovac. I am here on behalf of Respondent Alfonso Kennard Jr.
Okay. Before we get started with the case, I'd like to ask Mr. Kennard's counsel what your position is on the scope of the hearing today. According to our records, Mr. Kennard's answer was due October 22nd of 2021, and I don't believe we received an answer until January 19th of 2022. Is that correct?
That is correct.
As you may know, that Rule 9.03 provides that if a timely answer is not filed, that the board shall impose reciprocal discipline. In light of that rule, what is your position as to the discretion, if any, that we have in granting any relief other than reciprocal discipline?
Obviously, our position is that the board has discretion to go ahead and change the outcome of that. Procedurally, all I can say is it was late, as well as I know, and I'm not relying upon this, Madam Chair, that there was no motion to refuse alter notice or anything that this was going to be granted. So we continue to go forward in the process.
Do you have any authority that supports the board having discretion?
I don't in front of me. I certainly, if with the board's leave, we can continue to move forward today. If it behooves you, and follow up immediately with a brief on that issue. I can tell you, as I'm talking to you, I can see Mr. Canard writing on my periphery, so I might have something to add to that if you we'll follow up with briefing.
Thank you. Ms. Cates, what is the CDC's position on whether Mr. Canard can present defenses?
I think you have stated exactly where I'm going to go with this. Is the statutory language in these matters is absolute. It says the board shall upon, I can read it to you, but you've read it previously. There really is not any discretion in the statutory language. And so I don't think there's any discretion to be had. I'm certainly not in the business of telling the panel what they can and cannot do. However, if your question is, does the panel have statutory discretion? Not that I can see, and the respondent should not actually be allowed to put on defenses. However, in so much that the panel decides that you do have discretion, I'm prepared to argue why this should go forward.
Thank you. Under our internal procedural rules, the board chair has discretion to hear testimony from Mr. Canard, and so I'll exercise that discretion. We'll allow him to testify briefly, but we'll take under advisement whether that goes towards any particular defenses.
I understand.
This case, would you like to proceed?
Yes, thank you.
Bear with me, we might go the opposite direction. The court reporter has informed me that I need to slow down, so I'm going to try very hard.
I was wondering when she was going to call us on that.
This is what happens when you don't have these in person, you get more nervous. May it please the board. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure, based on Alfonso Kennard's professional misconduct and partially probated suspension in the state of Minnesota. The petition for reciprocal discipline in this matter was filed with the Board of Disciplinary Appeals on September 7, 2021. An order to show cause was signed by this board September 10, 2021, requiring respondent to show cause within 30 days of the order why identical discipline should not be imposed. As Madam Chair has already stated, that did not happen timely. However, here we are and we will continue on. Respondent was personally served with the petition and order to show cause on September 22nd, 2021 by process server Mark Whitmore, a private process server. Proof of service has been on file with this board since October 19th, 2021. On September 25th, 2020, a petition for disciplinary action was entered in the state of Minnesota Supreme Court in a matter styled in re petition for disciplinary action against Alfonso Kennard Jr., a non-Minnesota attorney, that states in pertinent part as follows. The above named attorney is a Texas attorney not admitted to practice law in Minnesota. Respondent currently practices law in Houston, Texas. Respondent has committed the following unprofessional conduct warranting public discipline. First count in the uptime matter. Complainant Stephen Cerny is an attorney who practices law in Minnesota. Respondent is an attorney who practices law in Houston, Texas, and is the managing shareholder of Canard Law, PC. Respondent is not currently and has never been licensed to practice law in Minnesota. Rule 8.5a, Minnesota Rules of Professional Conduct, provides that a lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in this jurisdiction. A lawyer may be subject to the disciplinary authority of both this jurisdiction and another jurisdiction for the same conduct. Rule 8.5b1 of the MRPC, the Minnesota Rules, further provides that for conduct in connection with a matter pending before a tribunal, the rules of the jurisdiction in which the tribunal sits applies unless the rules of the tribunal provide otherwise. In early 2019, Mr. Cerny was retained by Uptime Systems, LLC, to represent Uptime in a contract dispute with respondent. Uptime is a Minnesota company that specializes in technology services for law firms. Respondent's law firm, Canard Law, PC, was a customer of Uptime and has been receiving services from Uptime since 2011. In February of 2019, Mr. Cerny served respondent with a summons and complaint on behalf of Uptime. The complaint alleged proper jurisdiction and venue in Hennepin County District Court in Minnesota. Because defendant caused an injury in Minnesota and transacted business in Minnesota, and because the cause of action or some part thereof arose in Hennepin County, Minnesota. The complaint also alleged breach of contract and unjust enrichment relating to respondent's failure to pay for services rendered to Canard Law, PC by Uptime. On February 28, 2019, respondent filed in Hennepin County District Court a motion to dismiss the case. Respondent signed the motion as Alfonso Kennard Jr., pro se, even though the lawsuit was not against respondent, but against Canard Law, PC, respondent's law firm. Respondent did not associate with local counsel, nor did he seek pro hoc vice admission before filing the motion to dismiss with the Minnesota court. On March 30th, 2019, Mr. Cerny emailed respondent stating in pertinent part, see attached draft joint discovery plan for the attention of the attorney representing Canard Law, PC in the Minnesota lawsuit. In response, on March 30th, 2019, respondent emailed Mr. Cerny stating, I am representing myself and my firm. Thanks. On March 30th, 2019, Mr. Cerny wrote respondent informing respondent that Cerny verified respondent is not authorized to practice law in Minnesota and had not obtained temporary admission before filing the motion to dismiss with the court of Minnesota. Mr. Cerny requested respondent to provide the legal basis under the Minnesota law for 1, your purported representation of Canard Law pro se, and 2, practicing law without a license or temporary admission. Respondent failed to respond. There are quite a few pages that I could go on and continue telling you underlying facts of the case, and I'm happy to do so for the board, but as we have already been here for a long time, and I think you've probably read most of the pleadings, I think I can get to the point of the actual reciprocal without giving you more facts.
Thank you.
Unless anyone has any questions.
We are familiar with the facts from
Okay.
both of your briefing.
I will say that the facts kind of make a difference in this particular case, because a lot of what Mr. Canard and his counsel have argued in the things they have filed with this court, they seem to want to relitigate the underlying matter. So what I think is important for me to tell the board that it can't happen here. There are some defenses to reciprocal discipline. However, I don't believe that any of them actually apply in this particular instance. In my response that I filed to the motion to dismiss, that's exactly what I say. In so much as Mr. Canard and his counsel are making a due process argument, the defense for that would be that it was so lacking in due process that I'm really bad at reciting what that rule is. A due process problem is what they're alleging. I could go on and read these 4 pages of underlying facts, and the board will see that at every turn, the opposing counsel tried to tell Mr. Canard what he was doing was not going to be okay, and then when it did get to a disciplinary matter in Minnesota, the Minnesota counsel, almost ad nauseum, as I read it, I thought, oh my, repeatedly contacted Mr. Canard and said, this is your deadline. And then when that deadline passed, he said, this is your deadline. And when that deadline passed, he said, okay, really and truly, like, I'm giving you all the deadlines. Please just send me something. And Mr. Canard didn't comply with the requirements of the underlying disciplinary matter. There's been some more argument by Mr. Canard and his counsel regarding due process once the appellate process began. But once again, Mr. Canard, he states that he wasn't working physically in his office and so therefore may have missed some of the communications. But he doesn't ever argue that the communications weren't sent or the communications were not attempted. It was that he did not receive them because he was not where he told Minnesota that he was going to be. So I don't think there can be any question about the due process that was afforded to him in the Minnesota jurisdiction. In so much as Mr. I'm going to turn to my actual response so I can read from that. He makes an argument, well, about a statute existing in Minnesota that allows a shareholder to represent themselves. I cannot argue to what that statute says, how that statute is interpreted, because it's Minnesota law and I am not licensed to practice in Minnesota or versed with what that law says. But what I do know is that is an argument, a legal argument to be made either in the underlying disciplinary matter or on appeal. And I think in the motion for new trial, if I'm remembering correctly, that was attempted to be made, but the motion for new trial was denied. The appellate process has been concluded and the underlying court in Minnesota has not accepted that as a valid agreement. And this board cannot accept that today because what we're here to decide today, the board is impaneled to do, is to decide whether they should impose reciprocal discipline on the discipline that has already been established in Minnesota, not to open up a new Texas appellate process for Minnesota law. But there is another argument in the motion to dismiss that was made that says that petitioner is relying heavily on the Teeter case. This is not untrue in so much that just recently in October of last year, this board heard from Ms. Cassidy Teeter, I think it's Amy Teeter, and the board signs an order that in that underlying matter, Ms. Teeter was licensed, I believe, in Tennessee, it's Tennessee or Kentucky. She was disciplined in a non-licensing jurisdiction. I believe it's Tennessee. And a reciprocal discipline was instituted in Kentucky based on the non-licensing jurisdiction's discipline. And then Texas brought a further reciprocal disciplinary matter based on both the Tennessee and the Kentucky matter. And when this board wrote their decision, they used very specific language, and the language says that the reciprocal discipline imposed on Ms. Teeter here in Texas is based on both the Tennessee and the Kentucky disciplinary judgment. So to say that this board doesn't have any ability to do a reciprocal on a non-licensed jurisdiction jurisdiction would be inaccurate. Because of all of these arguments, I would like to introduce some exhibits at this time. And I'm sure I've learned going slowly. But at this time, I would like to introduce the following exhibits. Exhibit 1, certified copy of the petition for petition for disciplinary action entered in the state of Minnesota Supreme Court in a matter styled in re petition for disciplinary action against Alfonso Kennard Jr., a non-Minnesota attorney. Exhibit 2, a certified copy of a motion for summary relief entered in the state of Minnesota Supreme Court in a matter styled in re petition for disciplinary action against Alfonso Kennard Jr., a non-Minnesota attorney. Exhibit 3, a certified copy of Director's Memorandum of Law, which was filed in the state of Minnesota Supreme Court in a matter styled in re petition for disciplinary action against Alfonso Kennard Jr., a non-Minnesota attorney. Exhibit 4, a certified copy of an order issued by the Supreme Court of the state of Minnesota. I'm sorry.
That's all right.
But I appreciate you telling me.
Quite all right.
So do I.
Exhibit 5, an original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated April 5th, 2022, which indicates that respondent is licensed and authorized to practice law in the state of Texas. Respondent currently resides in Houston, Texas. At this time, I would ask that these be admitted.
Ms. Rolach?
Correct, yes.
Spurbeck? Any objections
No
to exhibits
objections.
1 through 5?
No objections.
1 through 5 are admitted. Yes, thank you.
And at this time, the commission seeks a 30-day suspension as reciprocal discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure.
Thank you, Ms. Gates. Ms. Bovett, would you like to give an opening statement or launch into your presentation?
Madam Chair, it's kind of just one of the same. I'll just launch into it if that's okay with the board.
That works fine, thank you.
And if the Madam Chair and the board does not mind, I'm going to self-time and hopefully be more efficient.
Efficiency is always appreciated.
It's an attempt. I can't tell you how many times I've said just one more question in the deposition and been there hours later. If it pleases the board, Madam Chair, my name is Ellen Sprovak. I do represent Respondent Alfonso Kennard Jr. I hope to get this done in 20 minutes. My goal is to start out with my argument and then based on an opinion from here in the last few years in Ms. Robin Barry's case, I noticed a distinction between the panel wasn't sure what was argument and what was testimony. So I will break up my speech with argument and then bring Mr. Canard forward for sworn testimony. I'm not worried about you all not being able to hear me. I've never had a complaint about that. However, my high school English teacher texted me this morning and told me to slow down. So I have heard that. Please, if you need to interrupt, I will do my best to speak slower. By way of introduction, I have been practicing for just about 25 years here in Texas, and after 21 years at the same firm, I recently, in June of 2021, moved over to Mr. Kennard's firm, probably our certainly most often competitor, maybe the biggest competitor, and based upon what I saw with Mr. Canard and his practice and his abilities. In fact, I worked kind of opposite in my case, and that's why when I was leaving, I contacted Mr. Kennard and his firm. Usually I handle a case from start to finish, and this is one that I came into once the petition was served. And so when I come in a situation like that, my first job is to look at it neutrally, I think, and try to look at it neutrally and see what I think. And I have to kind of get above the picture and look down and almost kind of navigate myself through the claims and the contentions and what really happened versus what's perceived to have happened. And the best way I can come up with what's going to be argued or presented to you all is that the best analogy I can come up with, actually surprisingly for me, relates to sports and the instant replay. So here we have a situation in Minnesota, and Mr. Canard will explain how he got there. But what happened is in Minnesota is a decision was made that certainly our very strong contention is that it was an infirmity of proof, and to do a reciprocal discipline, a mere reciprocal discipline here, would be a travesty of injustice. And I know phrases like travesty of injustice we hear a lot, and it sounds kind of dramatic, but I believe it would be in this case. And the reason is why we're not trying to relitigate the case. We're utilizing the tools given by this board and panel and the commission, is that we have affirmative defenses in 904. There are 5 of them. We believe we can meet all 5, but we only have to meet 1, and the standard is clear and convincing evidence, and Mr. Canard can do that. So the decision that was up in Minnesota was a final decision up there, but it is so erroneous as it cannot be applied in a mirror-like fashion here. And so what I look at that is we have an opportunity here with more knowledge, in the statute referenced by Ms. Cates, is that there's a Minnesota statute. I believe it's Exhibit 3 in y'all's exhibit packet, and it's Minnesota Statute 48102. And what it is it discusses the exceptions to the unauthorized practice of law. And Section 15 specifically says a sole shareholder of their own company can represent their corporation in court. And what we're going to get to with Mr. Canard has been at its formation 100% shareholder, was at all times relevant to this case, the sole shareholder, and is now the sole shareholder of Canard Law. So under the Minnesota statute, I don't practice law in Minnesota either. Mr. Canard was doing exactly what he was allowed to do. And sometimes it's sort of a trait. I can't see the forest for the trees, because everybody was worried about Mr. Canard being a lawyer and we were not licensed in Minnesota. But the real issue is he was allowed to practice representing his corporation, a corporation which he, besides practicing law, handles all the vendors, handles the move on the furniture, handles hiring receptionists, handles all of the administrative jobs there and always had. So what he was doing, and it was referenced that it was on the pleadings, he was appearing pro se. He did not say he was licensed in Minnesota. So that's what's important. And where we are now is we get to step back with this knowledge of the statute, and we get to look on this instant replay. And if you've all ever seen, I think football first, and I think it's a replay, but lately I've been seeing it more on baseball, where if somebody's sliding in a second, and there was one the other day I saw, I'm not sure it might have been Rangers, but I'm not supposed to talk about them in Houston. So if somebody slid into second, they looked like they were for sure out. They actually pulled their leg back, stopped the slide, and like hopped over the base. And so from this angle, it looked like they're out. This angle, it looked like they're out. Sometimes you get to this one angle, and it's like, whoa, no, he was clearly safe. And where we are today is that angle, the angle that says there should have been no underlying discipline. There should have been no underlying issues to take them to any kind of grievance or discipline in Minnesota, and there shouldn't have been anything that came here because the underlying issue didn't happen. It's sort of
with all due respect, we aren't here for an instant replay this morning. We're limited to, if we can discuss the defenses at all, it's the identified 5 defenses. So we're not going to relitigate what happened in Minnesota. With that in mind, my question is, was this defense or this argument raised in the Minnesota disciplinary proceeding?
This defense was raised factually, yes.
Was it the legal argument that Mr. Canard attempts to make now, was that raised in the Minnesota disciplinary proceeding?
The facts of the legal argument were raised. To answer your question very succinctly, I don't believe that the legal argument of that statute was raised. But you will see through these exhibits where Mr. Canard told the Minnesota disciplinary, the bar, that he was 100% shareholder. It's in emails, it's in writing, it's how he always talked about it. And so he was always told that he was 100% shareholder, and he was there representing himself. So to go to that, the first thing is the infirmity of proof. So I understand we're not supposed to relitigate. I totally get that. And it is a fine line. But at the same time, under the defenses of 904, which there are 5, and B is infirmity of proof. And it says that what the board has a duty to do in the center of the affirmative proof, if the facts applied to the law got the completely erroneous decision, then we have to look at that as the infirmity of proof. Because Mr. Canard was doing nothing wrong in Minnesota. And
Is it Mr. Kennard's position that he was justified in violating the court's order to him because he disagreed with the order?
with that same due respect, I don't think that was Mr. Canard's position. He didn't violate the order, and in fact, when we get to Mr. Canard on the stand briefly, item 2 of the docket sheet was that Mr. Canard did indeed hire local counsel to appear pro vice. And so, by way, again, of explanation, not excuse, opposing counsel decided to file, and I never heard of this, is file a motion to get rid of Mr. Canard off pro vice and had that removed, and that's kind of what started the ball rolling. So Mr. Canard did actually jump through hoops, even though he was allowed to do, turns out retrospectively, he's allowed to do what he did. He indeed jumped through those hoops and was pro vice for a period of time in Minnesota.
The docket sheet that you submitted with your briefing doesn't have the cover page on it. Was that docket sheet from the state court proceeding?
That was from the federal court, Your Honor.
Is there a reason why you didn't include the cover sheet that would have shown what?
No, I can't imagine that we didn't, and if we did, it was just purely oversight. And it's something we can provide with that. I have no problems about that. And as the person who's signing off on these, I take all responsibility for that. So that could possibly be it. And so that's where we get to that whole under C, 904, on these affirmative defenses, that if we know it's wrong and it shouldn't have happened there because he didn't violate under the Minnesota statute, he didn't violate any law, he didn't do the unauthorized practice of law, then if we give him the same reciprocal discipline here for something that he didn't do in the first place, then it is a travesty of justice. Because he's been disciplined there, and it's really important to note, Mr. Canard will tell you, he didn't practice law in Minnesota, he didn't put a shingle out in Minnesota, he didn't apply the law in Minnesota, he got sued in Minnesota. And he couldn't afford to hire outside counsel to handle all of this. This is his company, it's 100% him, it's a professional corporation, it's got his name on it, his face on it. He told me not to tell you, but I'm going anyway. When you walk in the door, his face is there. I mean, this is Canard. It is Canard law, and he's the 100% shareholder. So if we go after him again for that, for something that shouldn't have happened in the first place, then I don't know what it is other than a travesty of justice, of injustice. And by the same token, Mr. Canard, so one of the 904 defenses that y'all look at is their same discipline here. What would happen if that happened here and not in Minnesota? And if he had been practicing, he's licensed to practice here, so he's not going to get the same discipline here that he would there, because he's licensed to represent his company here, and there he was allowed to do it as the sole shareholder. So it's kind of a unicorn case in a couple of those reasons. And the number or letter E that you'll look at under 904 is that the state misconduct is not misconduct here. It's not. It warrants different discipline because it really doesn't warrant any discipline. And the due process thing, Mr. Canard can certainly testify to, but on the fifth element for us, the due process element, there was lots of communication with Mr. Canard and the bar. There was lots of communication going up to it. The due process, we argue, was in the Minnesota Supreme Court, not below. And the fact that he didn't get any notice. They shut down his electronic filing ability. They shut down his email access. It happened to be that perfect storm of COVID, moving our office, not getting any electronic violations. As soon as he got it and in time, he did indeed file a motion to vacate. I think it was referenced earlier. It wasn't denied, it was rejected. They wouldn't even look at it. And in the letter, it outlines how it was timely. So certainly we would argue all of that put together, including Mr. Canard's testimony, he says that we have actually a motion to dismiss on file. We ask that the petitioner's case, claims against Mr. Canard, be dismissed. And at this time, I'd like to call Mr. Canard up, if I may.
Thank you.
And Madam Chair, I was going to go through the exhibits with Mr. Canard. Opposing counsel told me that there will be no objections. So if it pleases the board, I can just move for them to be into evidence at the end of Mr. Canard's testimony. So that's the best way that you all do it.
We can do it before or after, whichever
Okay.
is more convenient.
Well, I'll do it this way then. For the board, we have exhibits 1 through 8. They are described in front of you, and you all have copies of them. We would like to move those into evidence before Mr. Canard testifies.
Ms. Gates, do you have any objections?
And can you just show me which ones you're?
Oh, sure.
So I can make sure I'm.
Yeah.
I still have not seen that July 6th email.
It's in your package.
Oh,
we gave it
you're
this
right.
morning.
I apologize.
No problem.
Are you going to say what they are, what the exhibits are, so I have it for the record?
I'm sorry.
Will you say what the exhibits are,
Yes,
so
ma'am.
I know in the record?
Yes, ma'am.
You want me to swear them in?
Did you swear no?
I have not.
Would you please?
Raise your right hand, please. Do you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
Thank you.
Before we get started with this testimony, Ms. Cates, was there any objection to the exhibits?
I have a question.
Sure.
Who is Miss Bradshaw?
She is the executive director of TBLS, Texas Board of Legal Specialization.
Okay. I don't have any objection. I do not have any objection to these exhibits.
Okay, thank you. The board has concerns about Exhibit 2, given that it doesn't have any case style on it or indication of what court it's from or even what case. So I will admit, well, with that in mind, does the CDC have a position on admission of Exhibit 2?
Sure. I don't think Exhibit 2 has been, there is no way to authenticate this document as it's missing all case affiliation. I will say, for the record, I could object to all of these as being irrelevant because they're all one, really shouldn't be able to put on testimony because of the answer not being filed timely. But also, I think these are all going to go to relitigating the underlying matter, which I've already stated we shouldn't be doing here today. But in so much as, and again, there's rampant hearsay, but in so much as she's not offering them for the truth of the matter asserted, I plan on objecting to probably a large amount of the testimony Mr. Canard is going to give. So the exhibits themselves, I would defer to the panel on how much weight they want to give to them is really what this comes down to.
Thank you, Ms. Cates. We'll admit Exhibits 1 through 8 and give them the weight that we feel is justified.
Madam Chairperson, before I begin testifying, just by way of answering your earlier question, on looking at Rule 7.03 on the attorney's response, it states clearly that if the respondent does not file an answer within 30 days of being served with the order and notice, but thereafter appears at the hearing, BODA may, at the discretion of the chair, receive testimony from the respondent relating to the merits of the position. So I would like to thank the board and its chair for allowing us to present a response and testimony to the merits of the petition. So thank you.
You're welcome.
And I want to thank Mr. Canard for that. So that's helpful moving forward. Have you been sworn in yet?
I have.
May I proceed?
Yes,
Thank you. Please state your name for the record.
Alfonso Kennard, Jr., and I'm also Mr. Berry's former contracts tutor at St. Mary's Law School in 2001, Section B. And I hadn't seen her in 20 years, so it's nice to see you again. Alfonso Kennard, Jr.
Okay. Mr. Canard, briefly, is my caveat. Could you just give us a little bit of background about where you went to law school, which is now St. Mary's, your license date, your board certification date, things like that?
Sure. Born and raised in El Paso, Texas. I grabbed 2 suitcases. My mom sent me on a plane, very Rudy-esque. Never seen the campus. Went to the University of Notre Dame. Graduated in 4 years. Thereafter, came to San Antonio, Texas, where I went to St. Mary's Law School. Was a student body president there, and thereafter worked at an insurance defense firm, Thornton Summers, and I practiced insurance defense law. I moved to Houston in 2006, where I started working for a boutique labor and employment law firm. Not long thereafter, I was specialized. I've been worked with Marty Wycliffe at Epstein Becker Green through 2011, upon which I started this law practice. We're about to celebrate our 11th anniversary. I was board certified since 2010. And so I'm a labor and employment lawyer. That's what I do.
How did you pay for undergrad?
I had a full academic scholarship for trips home. I DJ'd on the weekends, and I did Hispanic marketing in South Bend for 25 hours a week.
And when did you open your own firm?
This firm started in 2011. I joke I went from the 54th floor of the Wells Fargo Plaza in downtown Houston to the second floor of the Torre Latina behind Gallery Furniture in Houston. And we started in a little space. Within 9 months, we had one of the largest labor and employment law firms dedicated to employees in the state of Texas. And over time have grown it. We've had to scale up and scale down at certain points. But we've been in active existence for 11 years.
Can you look at Exhibit 1 before you, please?
Yes.
Can you tell us what that is?
This is the certificate of formation of a professional corporation. When I established this law firm back in 2011. It indicates that I own 100% of the firm. As I sit here today, I own 100% of the firm. During the time in question, I owned 100% of the firm.
And I'm going to interpret some looks from Madam Court Reporter and ask you to slow down a little bit.
Sure.
And I will tell you, I know I do this when I read, I talk faster, so I try to remind myself to speak slower when I read.
In the interest of time, this document indicates that I started this law firm as a 100% shareholder. I continue to be a 100% shareholder and was during the operative time. So that was the purpose of this exhibit.
Okay. Now, can you tell me why you were in Minnesota?
I was in Minnesota for a dispute. We had hired a company that had marketed to different law firms in Texas and all over the country for that matter. They were based in Minnesota. It's called Uptime Systems. I was actually one of their first clients. And even offered them strategies for growth, many of which they took on. And over time, I could tell the difference between servicing your actual clients and being in full growth mode. In that period and for an ongoing period of time, our cloud server was constantly crashing. There were days at a time where I had to send people home because we could not function. I filed a lawsuit in Harris County, Texas. Judge Michael Gomez looked at it and said, well, there is this binding Minnesota law provision. So at that point, I get sued in Minnesota by Uptime Systems. Now, I wish I could sit here and tell you that we were just cash flush and I could go out and hire a law firm in Minnesota to represent this firm. Now, in hindsight, looking back, unfortunately, the best the law firm could do and afford was me. That was its only option. I guess now I could have taken a default or allowed them to take a default in the state of Minnesota and then allowed them to try to come here and domesticate it here in Texas. I opted to let the court know I'm here pro se. At no time did I represent to this court or this tribunal or anyone that I was a Minnesota licensed attorney. I was there to defend this corporation. Oftentimes, folks see you as a lawyer, but forget that there is a business component to being a lawyer as well. I wear many hats. I was not there as an attorney. I knew better. Had I not known better, the magic words of pro se would not have been incorporated into anything and everything that I filed there. I was there as a business owner. And I made that clear throughout the entirety of the time that this issue was being raised with the Minnesota Bar, with the court system there, with the associate director at the Minnesota Bar, and with the court system. I am 100% shareholder of this company. I'm here in that capacity only. I also was in Minnesota. I hadn't formally gone there. There was no actual court of appearances. A lot of this happened during COVID. So when I say I appeared in Minnesota, it was never physically, but rather through advising the court that I would like to represent the entity that I own 100% of as its representative, but not as an attorney.
Speaking of that, can I get you to look, and it's a little bit out of order, Exhibit 5 in front of you? The description is respondent's renewed motion to vacate order, motion to accept filing, petition for hearing, and in the alternative, motion for reconsideration.
I've got it in front of me.
Okay. Can you tell me why that's an exhibit as far as you understand?
Well, this is an exhibit because it goes to show that at every possible moment I had been communicating to any tribunal that I am 100% owner of this firm. Now, one thing that, shame on me for, I should have, in this process, realized the exact number of the statute that allowed me to do what I was doing there. I did not. I did not cite the actual rule. In fact, Ms. Sprovach, in her brilliance coming in after the fact, was the one that discovered the codified version of this statute. The entire time, however, I have made it known, and if we look at page 2, paragraph 12 of the exhibit, it states that I am 100% owner of this firm, and I have arrived in Minnesota strictly as the equivalent of a pro se litigant, not as an attorney.
Can you tell me how you signed that letter if you look back to the end of it? Or that motion?
Pro se. Pro se respondent, licensed to practice in Texas only.
And what is the date of that motion? Do you see it anywhere?
This was submitted on, signed on April 1st, 2021.
Okay. And was that before there was any petition for reciprocal discipline here?
This predated any petition for reciprocal discipline in the state of Texas.
Okay. Would you then look at Exhibit 4, please, which is identified as a description as a letter to Office of the Appellate Courts dated March 31st, 2021. Do you see that?
I do.
Is there anything important in this letter that jumps out at you as to why you wanted it as an exhibit?
Well, I think there's several things of import here. The first is that, well, let me backtrack a little to preface the importance of this document. Good, bad, worse, or indifferent, was not receiving the notifications from the Minnesota court system. I know that Ms. Cates has indicated that I was not cooperating or participating. That is not accurate. I did, on numerous occasions, both via email and via telephone, advise the Minnesota bar that my response is very simple. There wasn't anything more for me to say. There was nothing I could fully brief at that time other than to tell them, I am not here representing anyone else. I, as the owner and chairperson of Canard Law PC, did not grieve myself. I would have, under normal circumstances, Canard Law PC would have been the injured party. I advised this on numerous occasions. It was not satisfactory, clearly. They were hell-bent on the notion that you're here practicing law in Minnesota and you're not licensed here.
Mr. Canard, I haven't seen any communications with the Minnesota bar prior to your motion to vacate order that's exhibit number 5. Have you provided any evidence of those filings or communications? It was over the phone with Ben Twong, and I guess we could have subpoenaed him to be here. He's the gentleman that I've been working with at the Minnesota bar. Now, these emails, there's a plot twist here. So the judge in the state of Minnesota, the state court judge, entered an order that allowed for Uptime Systems to discard the entirety of everything that was on our cloud. So I surmise that some of these, and that happened later in the process, so I surmise that some of these documents that me and my staff went to great lengths to locate and identify were part of that old server system, which upon an order from the Minnesota State Court allowed Uptime Systems, who hosted our cloud documents and all those things, to erase and discard them. So I don't have them. I wish I did, but
my testimony as both an officer of the court is that I, in fact, indeed communicated this sentiment in writing and over the telephone in no uncertain terms to the representatives at the bar in Minnesota. At that point, they then kicked it over to the Minnesota Supreme Court because the bar does not have the ability or capacity there to impose this type of discipline. And the reason we're here today, and what it states clearly on the show cause order, is that I am here for the unauthorized practice of law in the state of Minnesota, and they are asking for reciprocal discipline to be issued because I practice law in Minnesota when I shouldn't have. This letter is further evidence. It was sent once I received a communication via snail mail, certified mail from the Minnesota Supreme Court. I responded timely. When I received notice, they're saying that I would have needed to have responded by a certain day, which would have been an impossibility given the fact that the order was issued on a Tuesday but was not sent from Minnesota until a Friday, presumably the next Monday. So by the time I got it, and it's clear when it's received, I then have the ability to submit it. This letter also indicates that we took great lengths to provide a response, which is Exhibit 5 that Ms. Provok discussed with me earlier. That was what is referenced in this letter. We enclosed a check for $100, which got later returned. Our request in the motion to vacate was also returned, but this letter spells out that we were attempting here to cooperate once we received notice of these claims, which we did, and it was summarily rejected. I can't control that. But the letter indicates that on March 31st, we did in fact send via Federal Express a letter outlining when we received the notice and the efforts we took to respond to that case at bar in the Minnesota Supreme Court. And we also got to remember that the judge in the federal court where I pro-hocked in, I spent $500. I hired Mike Manenko. I could afford $500 to hire a local counsel who pro-hocked me in, even though I didn't need to do that. It was not necessary because I was not necessarily there as a lawyer. I was not, in fact. I was there as a business owner and could have dispensed with the whole process of getting pro-hocked in because it was unnecessary. I did so in an abundance of caution because I'm trying to comply as best I can with the rules. So that, although it was superfluous and unnecessary, I still was granted the pro-hoc. It was later revoked, and the case was sent back to the state court. The state court then said, Uptime Systems, you can go ahead and delete all their stuff, and we're going to issue an order in favor of Uptime Systems, and that was it. But I, at all times, communicated to the state bar folks in Minnesota that I'm just here for my firm. I'm not here representing them. I was like, Ms. Teeter, I get it. She was out there soliciting clients in Minnesota. She was out there. I guess she scammed some clients, didn't do some work, didn't appear at anything. I'm here today because it's important, and I get it. But at no time, like Ms. Teeter did I ever accept any payment from a client or would-be Minnesota client. At no time did I solicit a client in Minnesota. I was there strictly to represent the interests of this firm, the people that work there, their families that rely on the income derived from this firm. That's why I was there.
I forgot that you forgot you were testifying for a minute. I was going to argue to you. So, let me ask you to look at, so just for the record, Mr. Canard, you were looking at Exhibit 4, is that right?
Yes, ma'am.
And if you go down, there should be number 1 through 10 on the front page. Do you see that?
I do.
Number 2 says respondent. That was you, is that right?
That's correct.
Was not given notice of the order electronically. Can you explain your understanding of that to us, please?
Right. So this is, again, we're in the midst of COVID-19. We have all our staff working remotely. And they're still working remotely to this day. because I wanted to give everyone the opportunity to get their child care in order before I bring everyone back to the office. We're moving back soon. I may not be allowed to practice for a period of that time, but we're all coming back, and COVID made it very difficult to get certain communications. We had moved offices, our lease had run up at our previous building. We hadn't moved into a new building space because of COVID. Everyone was working remotely. So 99% of what we receive now anyway is received electronically through either the ECF system or now the Tyler Tech system here in Texas. But everything we get is electronic. I was kicked out when my Pro Hoc Vice was removed. Not only could I not file, I couldn't even log in my entire credentials. So I can log into Pacer today and look at any other jurisdiction in the country, sans Minnesota. I am blocked from even today from going into the Minnesota filing system. I received no notice. So we're looking at that docket sheet. A big chunk of that I wasn't getting. So even then, so when an order was issued, we didn't get it. They relied on snail mail. Eventually we got it. Eventually I got the last one. Thank God we received that one. And it didn't get lost in a former receptionist's trunk who was working from home. We got it. The minute I got it, I responded, but we did not receive, like we otherwise would in any other case, notice of any of these proceedings that were being held against me via electronic means.
I also notice here, you state that in paragraph 8 or number 8, that the letter that you got was postmarked on March 12th, but was not issued on March 9th, is that right?
Correct. The letter that we received was postmarked on the 12th for an order that was issued on March 9th. So by the time we would have received it via certified mail or otherwise, would have already kicked into the next week, because that March 12th was a Friday. So presumably it didn't go out via certified mail from Minnesota to Texas until that Monday, which makes sense that I received it in my hands on a Thursday and responded thereafter, which would have been timely.
And you sent it via FedEx, is that right?
Yes, along with a check for $100 for the filing fee.
And I see that in the last paragraph. Why did you send a check for $100?
There was no way for us to get into the Minnesota electronic system in order to make an electronic payment. So not only was our access to anything Minnesota related restricted, there was no means for us to go in and pay the fee electronically. So I submitted the check when we FedExed our motion to vacate.
And as far as you know, was this your letter in motion? Was it denied or was it returned?
It was outright returned and rejected. It was not. The merits of it were never heard, which, as far as I'm concerned, and maybe someone else, that's not due process, but that's not for me to decide.
Can you look at Exhibit 3 briefly, please?
Yes, ma'am. Can you describe which?
Exhibit 3 is the Minnesota statute 48102.02.
Yes, ma'am.
And if you go to, in parentheses, 15.
We're familiar with the legal arguments, so I don't think you
I'll just
do
ask,
that.
thank you. I'll just ask the board to take judicial notice of the statute. Let's look at Exhibit 7 and then 8, please. 7 is a December 21st, 2021 email from you to Mr. Timothy Baldwin. Can you tell us who he is, as far as you know?
Yes, Timothy Baldwin is an investigator with the Texas Bar, and he had reached out to me and asked if this issue here had been self-reported.
Madam Panel Chair, in the interest of time, I will go ahead and make a relevancy objection to this particular line of testimony. The Office of the Chief Disciplinary Counsel is not here to say that Mr. Canard did not self-report. We're not here to argue about that. So in so much as Mr. Canard wants to say that he self-reported to a member of the Office of the Chief Disciplinary Counsel. I'm not here to argue against it, but I don't think it's relevant to any of the defenses or any of the case for the reciprocal discipline.
Ms. Rovech, why is this relevant?
Well, because Mr. Canard, one of his defenses was that he did declare this, and the bar had already told him it's not an issue. He self-reported in that email to Mr. Baldwin, and in the next email, he explains to Ms. Odessa Bradshaw, who is the executive director of the Texas Board of Legal Specialization, he informed her that he did report this to Mr. Baldwin and Melissa Jordan, who are both, I know she's disciplinary counsel for the state bar. I'm not sure what Mr. Baldwin's position is.
He's an investigator with the state bar, and he reached out to me, and my understanding of the conversation, to avoid any hearsay arguments, my personal understanding of that conversation was that he wanted to know, from what I understood, whether or not I had self-reported. So there's also Exhibit 8 where I self-reported and gave a detailed description of the events surrounding what happened in Minnesota to Ms. Odessa Bradshaw, who oversees my board certification, and that's dated July 6th, 2021. And then I also confirmed to Mr. Baldwin via this email, I confirmed it, that
Yes, Mr. Canard, I'm going to sustain the objection. There's no allegation that you failed to self-report, so I don't think that this line of testimony is particularly relevant. And we are probably getting close to your 20 minutes, but we're not over.
And I think we're right, honestly.
Yeah,
I'm sure a little bit over it. But I appreciate the patience that you all have with us.
We are familiar with the facts and the arguments that you're making, so if you could try to sum up in the next maybe
I will.
minutes.
Is there any, I'll ask you before I sum it up, Mr. Canard, is there anything else you would like to tell the board while we're here regarding the underlying situation, Minnesota's, and then the reciprocal discipline?
I would. Had I done the exact same thing in Texas, which is represent Canard Law PC, there would be no discipline. Having done so in Minnesota did not or should not have led to any discipline. I believe, my personal belief, is that an infirmity of proof where the actual facts are not connected to the actual law will lead to an injustice here because no rule was violated to begin with. I understand, and I had conversations with Ms. Cates, who's been great to work with early on in this process, that look, she tells me, I got to go forward with this. I get what you're saying, but after Teeter, I don't have a choice. I got to go after this. I would also say that, unlike Teeter, on the record, I have never solicited any client in Minnesota. I have never practiced law in Minnesota. I have only appeared in a Minnesota court system as a business owner and a business owner only. And as such, where no rule has been violated and no crime has been committed, Texas should not give reciprocal discipline when there should not have been discipline to begin with. I am overweight. I could have been a better husband when I was married. A lot of things I'm terrible at. One thing I'm good at is giving a crap about my firm, my clients, and the people that I work with, and the law. I at no time would go into any jurisdiction and knowingly or intentionally violate any of their rules. And as I understand the rules here, and again, thank you for indulging us and granting us the ability to offer testimony. As I understand the rules, if it wasn't a violation in Texas, I can't be pinged for it here. If there's an infirmity of proof, everybody missed it in Minnesota. It's crazy. Everybody missed it. But it happened. And it cannot lead to reciprocal discipline here. That's all I have to say. But thank you for allowing me to say my piece so that you may consider what we have presented here today.
Thank you.
And I just have a few minutes to wrap up, if I may.
Ms. Cates, do you have any cross-examination from Mr. Canard?
very, very briefly.
Thank you.
Can you stand here?
I can.
Okay. Mr. Canard, are you here saying that, are you arguing that the Minnesota Supreme Court or anybody involved in the disciplinary process in Minnesota did not give you notice of what was going on in the underlying case, the disciplinary case?
Are you talking about the disciplinary case within the Minnesota bar context, or once it got to the Supreme Court level?
Is it your understanding that when it got to the Supreme Court level, it wasn't still part of the disciplinary process?
I didn't get any notices until I received that letter that was dated March 9th.
That's not actually my question. My question is, are you here arguing that Minnesota didn't send you notice of these, or just that you didn't receive them?
I don't know that I understand your question, but if I do understand it, I am not contesting that a snail mail certified letter was sent on a letter dated March 9th from Minnesota to Houston, Texas. And all I can tell you is when we received it, and tell you that pursuant to their own rules, the clock starts ticking once it's received.
And do you contest, say as you're standing here, Tate, that the address they sent, that Minnesota, any of the parties in Minnesota would have sent something to you, was not a good address for you?
Well, so I can't speak to them. I can speak to us, and I can speak to me. We had a forwarding address from 2603 Augusta Drive, Suite 1450 in Houston, Texas, where we moved out of and had not had formal office space for a meaningful amount of time. The forwarding address, that's the post office, the forwarding address that we had listed would be to our new suite that as of yet have not moved into but are about to. So I can't speak to who on their end sent it to where. I know that we had forwarding instructions.
Did you give any of the forwarding instructions to any of the individuals that would have been dealing with the disciplinary process in Minnesota?
Had I known that there had been this proceeding in the Supreme Court system to begin with, I certainly would have. I would have logged in to the system had I been allowed to or able to update our credentials. But the answer to that would then be no.
Is there any requirement in the Minnesota Supreme Court or the disciplinary system in Minnesota that you know of that requires the Supreme Court or the Minnesota Bar to give you electronic notice of any of these filings?
I am not a Minnesota licensed attorney, so I could not tell you or answer that question.
I think just one more thing. It's kind of gone both ways here. You say you told them over and over and over again that you were the 100% shareholder, but also that you didn't know about the statute in Minnesota. So if you didn't know about the statute that you're now arguing matters, what was giving you the legal authority to appear pro se in Minnesota?
May I refer you to one of the exhibits?
Sure.
Okay. So if we look at the filing that was rejected, it's consistent with my earlier testimony that I have stated that I was 100% owner and that I am only here as a pro se litigant.
Excuse me, George, I think it's-
Oh, sorry. We have other copies, hopefully. I got it. Strictly for the purpose of representing Canard Law PC. Now, while I knew that I could appear pro se,
How did you know that?
because I don't know how I knew that. I knew that I could appear representing myself. I am Canard Law PC. I can represent myself. Everyone, and I think including the Board of Disciplinary Counsel, is still focused on the fact, mistakenly, and that's I think the thrust of your question here, because I'm a lawyer. At the end of the day, the statute doesn't differentiate. I could be a smoothie factory owner and I could represent myself. If I was sitting here on behalf of Alfonso's Smoothie Factory,
And
I know that I could represent. Allow me to finish, please.
Well,
I want to answer
I'm
your
going to
question.
object as non-responsive.
Okay. I could represent my company in Minnesota. Had Alfonso's Smoothie Factory been sued there, I could represent it. In this instance, Canard Law, I knew I could. Now, to answer your question, I did not have knowledge of the codified statute number itself, but it just so happens that I was right. I could do so. Now, the fact, I didn't even have the opportunity to raise that issue by the time I got home cooked out there. They didn't even hear it. I couldn't have raised it. But what we do know is that it is absolutely allowed by an easy read of the statute that 100% shareholder, which I've been telling the Minnesota Bar all along, is allowed.
I don't have any other questions. Thank you.
You're talking about this March 9th order from the Minnesota Supreme Court. Did you say that you did not receive that order until March the 26th? Is that right? Or March the 23rd? When did you receive the order?
If I refer back here, we received a letter on March 18th of 2021. So by the time we would have submitted the response via FedEx, it would have been timely under the standard of received versus when sent.
So you had an opportunity, when you received the order from the court, you had an opportunity within the time period that the Supreme Court allowed to respond to that order, right?
We did it, but they rejected it, saying it was untimely.
No, you didn't do it it was 14 days after the date of the order, but you got the order within that 14-day period and had an opportunity to respond, correct?
Pursuant to Rule 140.1, that presumes that notice had actually been afforded to respondent via the electronic system, which was not allowed, which we didn't have access to here. So the presumption in Minnesota is that we would have received it on the date the order was issued via the electronic system. That was not in play here, so that's why it's distinguishable. We didn't receive it. It was postmarked on the envelope March 12th.
I thought 140, I have it here, maybe this is, I just want to get this corrected. This is incorrect, but it says a petition for a hearing in the Supreme Court may be filed within 14 days after the filing of the decision of the order, unless the time is enlarged by the court. So the decision of the order, as I understand it, was March 9th, correct?
Correct, and we had no way to know about it.
And so the deadline for the rehearing was March 23rd, based on that 14-day period, correct?
If we had received notice electronically on March 9th, that would be absolutely correct. But because the only opportunity for us to receive notice would have been through certified mail, which we did not receive until March 18th, which makes sense if it was sent on a Monday.
Yeah, you said you received it on March 18th, so you had 4 more days.
We had 14 days from the date it was received.
14 days from the date of the order. So once you received the order, you had 4 more days in which to respond.
Well, that was not my understanding of the rule. My understanding of the rule was that we had 14 days from the date it was received. But again, I'm not a Minnesota lawyer. And if I got it wrong, it wasn't as a Texas lawyer, a Minnesota lawyer, or otherwise. It's someone that was out there trying to represent his company.
And then when you were at the district court, the state district court, did the court order you to put in local counsel?
I don't recall if they did. If they would have, I would have advised them what I'm advising this honorable board. We did not have the financial resources then to do so. We would have just had to have taken a default judgment.
And was there another order in the federal court revoking your pro hoc?
There was. They revoked my pro hoc on motion of Steve Cerny, which is the same lawyer that grieved me at the Minnesota bar level.
And what was your understanding why they revoked it?
My understanding of why they revoked it is that I was engaged in the unauthorized practice of law in Minnesota and that I had pro hoc during a suspension period or as a suspended Texas lawyer, which I was not. There was an administrative, not disciplinary suspension. I was on a red dot. My CLE hours hadn't been uploaded. As soon as I was made aware of it by Mr. Stephen Cerny, same lawyer, within 48 hours that was corrected, and it was then retroactively applied to as if there had been no administrative suspension to begin with. Those were the two reasons they stated for the pro hoc being revoked and ultimately it being sent back to state court. By the time it got to the Minnesota Supreme Court level, the only thing that they put forward was that they are disciplining me for the unauthorized practice of law only. And given the pleadings that were filed against me by the Office of Disciplinary Counsel, the only matter here pertinent is whether or not I engage in the unauthorized practice of law in Minnesota.
Does anyone else have questions for Mr. Canard? Do you have further questions, or?
Yes, and I'm going to preface it with saying it's probably 2 or 3, and I'm going to stick to it, Madam Chair. Mr. Canard, were you ordered to file pro hac vice or get local counsel?
I'm sorry?
Were you ordered by a judge to obtain pro hac vice status or get local counsel?
The clerk had suggested to me, if I recall correctly, to pro hoc in, and I did so in an abundance of caution. But again, at all times, I'd never represented myself as a Minnesota licensed attorney. If I had, then there would have been no need to hire local counsel if I'm purporting to be a Minnesota lawyer.
And did you obtain pro hac vice status?
Yes, ma'am, I did.
And what happened by way of procedure once you obtained pro hac vice status? What happened to that?
Well, exactly what I told Mr. Cleveland, that almost immediately there was efforts taken by the attorney for Uptime Systems to disqualify me. I spent probably the better part of a year or so in the state court level just deflecting motions to disqualify me because of the unauthorized practice of law issue. By the time we got to the federal court system and pro hoc in, because I thought I had to, we never got to the merits of the underlying matters relating to Uptime Systems, took my money and left my firm with no cloud service for days at a time.
Do you rely upon just one cloud service for your firm now? Or do you have 2?
No,
Is Clio cloud-based?
Clio is cloud-based, yes.
And then our 365 is also cloud-based?
Yeah, we only use a cloud. We are 100% paperless firm. But Uptime Systems managed everything. They had this predated your arrival, but Uptime Systems hosted and managed the cloud where everything was stored, in addition to providing the practice operational software.
And bear with me on this. Did I tell you that I had a very difficult time translating and transferring over to being paperless?
Sure.
It's hard for some of us.
I get it.
Lastly, you mentioned Teeter. Unlike Teeter, are you dual licensed anywhere?
I have not been licensed anywhere else other than the state of Texas. I have never applied for admission to any other bar, including Minnesota. I've only been a Texas lawyer. I only care to be a Texas lawyer. This is where my heart is. This is where I belong. And if the nice folks of this board and panel will allow me to continue practicing, I'd love to do it. But if not, I've done what I could here, and thank you for allowing me to testify.
I'm done, Mr.
Okay, thank you. Any other questions? All right, you may step
May I be
down.
excused?
Yes.
Thank you.
You're not leaving, are you?
I'm going to go back.
And then they go first, right?
They do go first. I think we're very familiar with the legal arguments that both sides are making, and so unless you have something new to say that we haven't heard before, I would ask that perhaps you waive closing arguments.
I do have 3 short points, no more than 3 minutes, that 2, at least 2.5, we haven't heard.
Okay,
So
Ms. Cates, do you have anything that you'd like to say, or would you like to rely on your briefing?
I have nothing new to tell you. Thank you very much.
Thank you.
if I may respond to an earlier question about the Minnesota discipline, the petitioner's petition, it looks like I said Exhibit 3 was the State of Minnesota Supreme Court Memorandum of Law. And that says on the first page that they suspended Mr. Canard for a minimum of 30 days for engaging in the unauthorized practice of law on numerous occasions. That's referenced throughout, and they reference a statute. Obviously, we don't believe that to be the case. and believe that Mr. Canard was allowed to do what he did. What was referenced earlier by opposing counsel, and I do want to take this time, because when I started, and may it please the court, what I didn't do was, and I try to do as often as I can in a world where I think, based on what I see every day, we need to be nicer to each other. Ms. Cates has been nothing but professional, and better than that, she has tolerated and had patience for my questions. And I'm not going to self-deprecate with my questions. This is my first and hopefully only time in front of this body, but I had a lot. So she has been extremely gracious, and it's extremely appreciated, because this is a fear-invoking environment from all of us, I hope. She did, I think, beyond her job. Mr. Canard referenced Teeter, but there's also a case that I heard earlier today that I look at for this court as well. It was a relatively recent decision from this board. It's in the matter of Carl B. Duke Jr. The important part of that was it was a judgment denying Muir-like reciprocal discipline, and that the argument is, and I understand it's a fine line, I'd probably characterize it this way: we are not litigating. We are saying there are 5 defenses, affirmative defenses that y'all offers. We believe we can meet them all, but certainly the strongest is that the law is clear that Mr. Canard didn't violate anything. And so we argue certainly under Duke, that we've met that very good standard of clear and convincing evidence, at least on that issue, that it's mere discipline shouldn't be given to Mr. Canard. It's a 30-day suspension is serious, particularly for the 100% owner of the firm, who didn't put out any shingle, advertise, who thought he was doing what's right. And what is important to me is I heard something earlier, and I'm not sure where I heard it, that Mr. Canard, did you know that you were allowed to practice law? Well, he said he didn't know, I believe, under the statute. But even if he didn't know, it's the opposite of people who say, well, I didn't realize I committed a crime. And we all say, well, you're charged with knowledge. We have the knowledge now. Mr. Canard did what he did, and it wasn't a crime, and so how can we punish him for something that wasn't any kind of a violation or unauthorized practice of law in the first place? So he received that discipline there. Let me tell you something, it's public. It's come back to bite him over and over and over. There are people who create blogs, and it's all they do, or go out with their decisions from this place, and it's gotten very, very ugly. It would certainly be a dream if we could understand that. I think we've met the clear and convincing standard that Mr. Canard shouldn't receive any discipline. We do ask for dismissal. I do appreciate the patience and courtesy offered to us to go forward today. I do believe that what Mr. Canard cited under Rule 7 applies going forward. I've also addressed that in response to the motion to dismiss, in response to amendment motion to dismiss, and after I answer, I would argue that the opposing counsel would waive that issue, but to the extent it has not, I believe we can go forward, and we appreciate all of your time. We realize that these are volunteer positions. Thank you for the opportunity to be here, and we look forward to a decision, not giving reciprocal discipline and ultimately dismissing the grievance or the discipline action against Mr. Canard. Thank you all for a very long day and your time.
Thank you. Thank you both for your presentations. Does anyone from the board have questions for the witness or counsel? All right, thank you. We will take it under advisement, and you are excused.
Thank you all.
Thank you.